All right, everybody, we will be starting now. So, Michelle, please take it away.
Thanks, John, and welcome to our first webinar in our compliance series, Wage and Hour Attorneys' Best Tips for Staying Out of Trouble, presented by EPAY Systems. My name is Michelle Lancher-Smith, and I am the Vice President of Marketing here at EPAY Systems. I'd like to extend a warm welcome to all of you on the line with us today. We have over 30 people joining us from across the nation. Welcome to our customers. I'll just name a few that we can see online with us: Able, ABM, Healthcare Services, Harvard Maintenance. And welcome to all those of you that we may not have had a chance to get to know yet, but we look forward to getting to know you more. We have many different firms across various industries, but all of you have a couple of things in common. When I take a look at who's on the phone, I can probably tell that these things might be giving you some issues. First of all, you all face a very challenging, complex labor environment, one where your workers are distributed across many locations, making it difficult for consistent management policies and procedures. And two, you probably are managing compliance issues, such as overtime pay, meal breaks, employee travel. These type of things can be a real concern, and because you have a distributed workforce, it's even harder to manage. Well, that's where EPAY comes in. EPAY is in the time and labor management business, and we specialize in dealing with companies that have very complex and distributed labor environments. In fact, the more distributed, the more complex, the better we like it. Our organization understands all of the challenges and limitations a company with employees scattered everywhere deals with as it relates to deploying new technology and managing issues like compliance. In fact, we have put together a white paper that you may be interested in, and you'll have a chance to tell us you want it at the end of today's webinar. It's called Best of Breed Time Tracking Solutions for the Distributed Workforce. So if you think that might be of interest to you, please make sure that you do say yes that you want it at the end of today's session. But as I was saying, distributed labor can present many challenges, but labor is really probably your largest cost. Complex pay rules, shift differentials, employees working one task in the morning and a different one in the afternoon, employees working at customer sites and moving from job to job and traveling. These are pretty tough for most time and attendance systems to handle, but not for EPAY. Our uniquely flexible payroll engine can handle complex union rules and state regulations, not to mention your own complexities of the nature of your business. So what we try to do is two things, two main benefits for our clients. One, we help them reduce their total labor costs by 5% or more, and we see this time and time again as we help them automate their time tracking across their sites. And two, we help them lower their overall risk in facing compliancy issues. You see, we have compliance features built right into our system. So you're ready to go and to address some concerns that you may have across your sites with compliance. And speaking of compliance, it's not something to be overlooked in today's labor environment. Federal court filings of wage and hour class and collective actions have increased more than 500% since 2000. The Department of Labor recently increased its investigative staff by 40% to crack down on non-compliant employers. Indeed, the vast majority of class and collective actions filed in state and federal courts continue to be wage hour cases, not racial discrimination. So when they do come knocking on your door, it gets pretty expensive. The average reported settlement is $8.5 million per case with a per plaintiff average of $5,600. Allegations run the gamut, unpaid overtime, off-the-clock work, misclassifications of exemption statuses, failure to pay minimum wage, improper tip pooling. It goes on and on. So could you be at risk? Probably most of you on the line would say most definitely. That's why today I'm thrilled to introduce to you our guest speakers from Cypher Shaw for today's webinar on compliance. They really do have the best tips for staying out of trouble. Cypher Shaw's defense of employers in wage and hour litigation has become one of the hallmarks of the firm's nationally recognized employment law practice. Its wage and hour litigation practice group consists of more than 80 attorneys in offices across the country. They have litigated hundreds of complex wage and hour cases in nearly every federal jurisdiction and in courts of almost every state, as well as before administrative agencies and on multi-jurisdictional basis. Today, we are very fortunate to have two of the firm's prominent partners in the wage and hour space, Noah Finkel and Rebecca Bromett. Welcome, guys. Let me just tell you a little bit about them. Noah is a partner in the Labor and Employment Department and the Wage and Hour Litigation Practice Group at Cypher Shaw's Chicago office. His principal area of concentration lies in wage and hour matters, in which he has represented companies in more than 90 actual putative, collective, and/or class action matters under the Fair Labor Standards Act and/or the state wage and hour laws. Noah is one of 3 editors-in-chief of the treatise Wage and Hour Collective and Class Litigation. Now, this is a 912-page book devoted to litigation of wage and hour matters. He knows his stuff. This is the book on wage and hour litigation. Now, Rebecca is also a partner in the Labor and Employment Department at Cypher Shaw's Chicago office. Rebecca's wage and hour practice focuses on defending employers across the country in administrative matters and in collective class and individual actions under the Fair Labor Standards Act and state laws in federal and state courts. She frequently speaks at seminars and conferences on all human resources issues, especially wage and hour matters. And Rebecca has authored the Illinois Employer's Guide to Wage and Hour Laws, published by the Chamber. She also contributes to many, many other publications, and she is a member of the ABA Fair Labor Standards Legislative Committee. So welcome, Noah and Rebecca. Thanks for joining us today. I'd like to talk just really quickly about what you do if you have a question. So I'm sure many of you will have one. All you need to do is simply type it in the question box, which is at the bottom right section of your screen. We'll be monitoring those questions, and Noah and Rebecca will attempt to answer your questions throughout their presentation. All right? So let's get started. Noah, let me turn it over to you to discuss some of the trends you're seeing in wage and hour litigation.
Thanks, Michelle. We are in an environment in 2013 where we anticipate that the cases that we'll see are going to be very similar to the cases we've seen over the past couple of years, just more of them and brought in a larger and more sophisticated way. They're going to involve probably a lot of the same types of issues that we've been seeing for a couple of years. These include all the exemptions that we're going to talk about today. We're going to see increased challenges to the way employers calculate overtime and whether they're putting all the correct compensation into the regular rate when they include overtime, when they pay overtime compensation. And as always, we're going to see a lot of claims of off-the-clock work and failing to pay for all time work, whether that be through time shaving or just failing to account for all the time employees spend on their various tasks. We're going to be discussing that today under the rubric of top 10 mistakes that we tend to see that lead to collective or class claims. But first, we're going to talk about some of the national trends that we're seeing. We're having some trouble here with our PowerPoint, Michelle. Well, we'll keep going. What we're going to end up seeing will be, as we said, there's going to be increasing aggressive enforcement by the plaintiffs' bar. They are doing these in a much bigger way than they used to. Like any business, they get more sophisticated the more they do things. And frankly, as they've settled a lot of big cases, their war chests are growing, and they're better able to pull off a lot of the enforcement efforts that you're seeing. What they're doing is they're often combining with each other, and then they're hitting one industry. And the way they'll typically do it is they'll start with one client for one company who they obtain and they file a lawsuit. And then they're able to obtain conditional certification of the case. Any of you who have faced FLSA lawsuits probably are familiar with the conditional certification stage, where typically a notice goes out to all other employees in the same job position at the same location, at the very least, sometimes other places. And they will then attract new clients through that notice to join that particular case. They'll then talk to that client about where else they've worked in the last couple of years, and they'll stay in touch with that client to see where they go. They often go to other employers in the same business. That's where you get your next lawsuit. They then file a motion for conditional certification, obtain it, send out a notice, and get additional people. And it goes on and on and on, and pretty soon the entire industry has been sued by that particular set of plaintiffs' law firms, regardless of where they are, because the last people do move around. And so many of these cases are brought on a national stage. In addition, we're seeing more efforts to find new plaintiffs through areas other than just the notice process. They are blanketing workforce through, used to be just postcards, but now it's it's emails and Facebook and Twitter. They are becoming very adept at using social media to identify potential clients, and as a lot of you have seen, it's very difficult for employers to stop employees from even from at work conversing on social media about their working conditions. So they hold all the cards in how they can obtain clients these days. And so indeed, in 2012, we saw more than 7,000 lawsuits filed into the FLSA, and that doesn't even include the state law class actions, of which a vast majority of them are, probably a vast majority of them are filed in California, but certainly we're seeing them in other states like New York and Illinois as well. And Texas is a big state for it too. We see a lot. Well, in Florida, we see it in federal court, but lawsuits under state law are very common now. We're seeing some fairly large settlements these days. You can see them on the next slide. I won't spend much time on this, but you can see they involve a variety of types of companies. They're in public entities. You see pharmaceutical companies, financial services companies, drugstores, the largest city in the country, big energy, retail, and the final one, Spearmint Rhino, doesn't involve chewing gum or large animals. It's actually a company that uses the services of exotic dancers. Who would have thought that there was a lawsuit involving $12.9 million for that? But you can see the typical claims that we get here. A lot of it relates to exempt status, and some of it relates to state laws on the timing of payment for various employees. And you can see on the next slide that these cases, when large settlements are filed, what happens? Other plaintiffs' lawyers are interested in filing cases too, and you can see that in the last 8 years, we've seen the number of FLSA cases double. In the last 10 years, they've more than tripled. In the last 20 years, they have quadrupled. In addition, the plaintiff's bar is not the only thing that employers need to fear. It's also the wage hour division of the Department of Labor. On our next slide, you can see that they are now increasing their investigations. They are making them corporate-wide. They frequently now try to assess liquidated damages, which are double damages, and they are working hand in hand with various community organizations to make these claims or make their investigations more frequent. And you can see that they have now increased the number of investigators that they employ. On the next slide, for a while, the number of investigators was decreasing as the plaintiff's bar got more active. But since 2009, they now are redoubling their efforts and, in fact, supplementing what plaintiff's lawyers are doing, not just kind of receding into the background while the plaintiff's lawyers take center stage. So we now want to ask you a couple. Questions and ask you to put your answers into onto your computer. The first one, and you'll see the collective answers as well. Has your company in the last 5 years faced an FLSA or state law wage hour lawsuit?
We'll give you some time there to answer it before we close it.
And then the next question, as you can see here, it looks like a little bit less than half of you have faced a lawsuit. That's actually a little lower than I expected, but that's good news. Let's try to keep it that way. The next question, and I'm guessing that the yeses are going to be a lower percentage on this one, is has your company faced a Department of Labor investigation from the Wage Hour Division at any time in the last 5 years? That'll be up on your screen in a second.
Yeah, and we'll give you, 20, 30 seconds to answer, and then we'll go ahead and close the poll, and we'll give you those results as well. All right, we're going to go ahead and close that poll.
Interesting. 59% of you have seen the DOL come. That's higher than we expected. Perhaps the DOL's new hiring of a lot of investigators is bearing some fruit for it. What I'd like to do now is I'm going to turn over the microphone to my partner Rebecca, who is going to talk about the mistakes that we tend to see in classifying employees as exempt from the FLSA's overtime requirement.
Hello, everybody. Great to be with you all this afternoon. Before we get started on this slide, I saw that we had a question in the chat room that actually probably should be mistake A, and that is employers who are using workers as independent contractors, and what are the concerns with doing that. And that's a necessary first evaluation, is to decide, are these workers your independent contractors or your employees? And the Department of Labor and various states are going after independent contractor misclassification quite aggressively. The full tests of whether or not somebody is an independent contractor or an employee are outside the scope of this presentation. But if it's something you all are interested in, we can certainly work with Michelle to do something like that in the future. But as a general rule, what you're looking at is, do you have the right to control the manner and means in which the work is performed? And if the employer has the right to control the manner and means, the manner is how the work is done, and the means is the tools with which the work is done, then the Department of Labor and most courts would generally find that kind of a worker would be an employee. So that's A. Assuming that you have employees, then mistake number one that we see often is our employers who say, we have somebody who works in our office and they receive a salary, so we don't have to pay them overtime, right? And on the slide Noah covered regarding the largest settlements in 2012, the vast majority of those were misclassification cases. That means that those employees allege they were entitled to overtime, but they didn't actually receive it. It could be for a variety of reasons. This mistake number one comes up frequently, and it used to be kind of a common way of thinking that if somebody was a white-collar worker, you didn't have to pay them overtime. Unfortunately, the DOL and the law does not actually follow that common sense approach. Instead, when you're dealing with office workers, generally you're looking at the administrative exemption. And when you're looking at the administrative exemption, there are three main points. One, are they performing office or non-manual work? If you have people who are actually doing sales work or are doing what we might think of as blue-collar work or hands-on work, manual labor, then those folks automatically will not qualify for the administrative exemption. The second issue is, are they doing work directly related to the company's general business operations or the company's client's general business operations? And that covers a wide range of work performed within a company, including the things you typically think of the running of a company, the human resources, the tax department, the safety and health department, marketing, advertising, purchasing, insurance, auditing, all of those functions that are necessary to running a company. That is what qualifies under that element of the administrative exemption. We have a note here that we often see folks who are classifying inside sales or customer service, thinking that those folks might fit within the administrative exemption. And I would encourage all employers to take a good hard look at those categories of employees to make sure that they truly do fit within the administrative exemption. If they're performing sales work, generally that's considered not covered by the administrative exemption. And if they're performing customer service work, then generally what courts would say is they don't satisfy the last element of the administrative exemption, which is that employees must exercise discretion and independent judgment with respect to matters of significance as they're performing their duties. And so what does this mean? I like to think of it as if you have two employees who are they both have the same title and they're sitting next to each other, they might do their job slightly differently, and both ways of doing the job are correct. So if you think of a human resources person who is applying a human resources policy, you would expect to have some differences and deviations in the way that those human resources professionals would go about applying policies. They're going to look at the facts differently. They might even consider different facts. They're going to see the facts through different lenses. They're going to apply the policy in a slightly different way. And those folks are hired because you want them to exercise their judgment in a good, sound way and make those decisions on behalf of the company. So this is where we see quite a bit of litigation, where employees allege that they do not have the right to exercise discretion and independent judgment in their job duties. And the classic wage and hour plaintiff, when that person goes to a plaintiff's lawyer, they suddenly will disavow having any responsibility in their job. This is where we always like to see self-evaluations or reports of they're describing their own job duties, because they're often at odds with what they might say in litigation. In litigation, they're going to say, I didn't have any responsibility. I just did what my manager told me to do. I followed a manual. I followed a guideline. There was a process map I had to follow. It was a black or white type decision-making situation, no discretion involved. So that is an area where companies should take a good hard look at whether the folks they have classified as exempt administrative employees truly are empowered to use their discretion and independent judgment. And with respect to matters of significance, I've often talked with employers who say, oh, yeah, this person has the discretion to decide how they perform their tasks during the course of the day or when they perform their tasks during the course of the day. They prioritize their workload. Most courts would probably say that's not with respect to a matter of significance. It has to be something significant to the company, not significant to the particular person.
And one handy way to think of discretion and independent judgment is think that in everyone's job, they have to get from point A to point B. Discretion and independent judgment is when, to get from point A to point B, you can take road 1, 2, or 3, and in getting there, you're looking at the pros and cons of road 1, the advantages and disadvantages of road 2, the pluses and minuses of road 3, and then you're making a decision on which one you're going to do, and there's not really a right or wrong answer to it. On the other hand, if someone's not exercising discretion and independent judgment, there's probably just one road to take. Sometimes it may even be difficult to navigate that road, but there's still only one road to take, and that's what they've got to do. And when they do that, they may be well-paid employees, they may be pretty important, they may be smart, but they're probably not exercising the discretion and independent judgment necessary for the administrative exemption.
Yep. Thanks, Noah. So we'll move on to the next slide, please. So the second mistake we see, and this is increasing in litigation, is our employers who say, this is a manager, so they're not entitled to overtime. And this is a hot area of litigation with respect to, especially with respect to assistant managers. And the reason is the test to qualify for the executive exemption, which covers those people who are people managers, is you have to manage a particular group of people within the organization. That's usually fairly easy to find and satisfy. And the people manager has to customarily and regularly direct the work of at least 2 full-time people. Usually a people manager, they have more than 2 full-time people. On the other hand, when we're working with companies and we're assessing whether they've properly classified employees, we say, look, it's a 2 full-time person rule, but if they're only managing 2 full-time people, they're probably not managing as their primary duty. They're probably doing something else as their primary duty. The third requirement for the executive exemption is really what has gotten a lot of employers into trouble. These people need to be vested with the authority to hire or fire other employees. So if it's the store manager is the only one who can hire and fire other employees, or it's the district manager we've seen in some cases who has the authority to make decisions about hiring and firing, then that's a problematic situation. The regulation goes on to say if they don't have specific authority to hire and fire other employees, then the employer has to take any suggestions or recommendations as to hiring, firing, advancement, promotion, other types of significant employment decisions, and they have to give particular weight to that person's recommendations. So this is designed to cover those situations where the manager doesn't actually do the hiring and firing. Human Resources does that. But Human Resources makes that decision based on the recommendations of the manager. So this is not where simply coworkers are reporting misconduct by somebody. This is truly those people who are doing what we think of as true people manager type jobs. So we'll go on to the next slide. And that this mistake number 3 is classifying all of your folks who work with computers as exempt. We see this frequently, especially when we're doing audits, whether it's the DOL coming in or whether we're doing anticipatory self-audit to make sure that we're doing everything correctly on the front end. Lots of people have all of their IT folks classified as exempt, and that really is problematic. The computer professional exemption is designed to cover those people who are doing high-end computer work. These are your architects, your programmers, your high-level systems testers. These are not, critically, they're not your IT help desk workers. Anyone who is a level 1 or a level 2 help desk worker probably does not perform the type of work that is required to satisfy the computer exemption. It's also important to bear in mind that the computer professional exemption is not available in all states. There's several states where it's not available, and states where the law covering the computer professional exemption is written differently than under federal law. Out in California, for example, it has a much higher pay requirement than it does under federal law. And it's so high, in fact, that some of our big multinational companies have gotten tripped up on that issue alone. One thing that we encourage employers to do is if the computer professional exemption doesn't apply to a particular group of employees, then we always look at an alternative exemption. And it could be that they're a people manager, which that's easy, okay, so we can put them in the executive exemption. If they're not a people manager and we have questions of whether they are going to fit into the computer professional exemption, then we would turn to the administrative exemption. And this is where, again, we're asking, are they actually performing work that requires discretion and independent judgment? Your folks at the help desk don't perform work that requires discretion and independent judgment, at least not with respect to matters of significance. it may be complicated for us non-computer people to understand what it is that they're actually doing. But generally, at the help desk, there is a right answer that they're aiming to get to. Whereas with coding or programming, for example, there's lots of different ways to do that, and somebody might need to look forward and anticipate what other system changes might be down the road, and there might be better ways to code something today to anticipate those changes down the road. That kind of a person is exercising discretion. So beware of your computer professional exemption. And with that, I think we're going to go to our next polling question.
Yep, and that should be on the screen now.
Yep. So the question is whether you think that at your company there are some employees who are misclassified as exempt. Go ahead and take a few seconds.
Okay, and we're going to close that here in a couple seconds now. So.
Got it. Split about 50-50 with a few more people who are saying yes. I would suggest that everybody take a good, hard, critical look at your exempt status of all your employees. I don't think that Noah or I have been brought in to do an audit of exempt status for a company with lots of employees where we haven't found at least somebody misclassified as exempt. Would you agree with that, Noah?
I would, and I think if you talk to a Department of Labor investigator, they're going to tell you that they're always going to find some of that too. They don't go after it quite with the zeal that a plaintiff's lawyer will. Sometimes they will take someone who kind of just sounds exempt and leave it alone. But as you saw from those large settlements, your biggest vulnerability comes with large groups of employees that plaintiff's counsel can do something with. So now we're going to talk about a couple other of our top 10 mistakes, and we're going to leave the exemption realm into some others. And mistake number 4 involves what are called regular rate claims. Now, these are kind of interesting. I think these are one of the next waves that we're going to be seeing. We've already started to see it a lot in the last about 2 years. And these claims are brought frequently because they are like shooting fish in a barrel for a plaintiff's lawyer. What they involve is we all know that overtime is time and a half of an employee's regular rate for all time worked in excess of 40 in a week, or under certain state laws, 8 in a day. But what's that regular rate? If you have an employee who's paid $20 an hour, the regular rate is probably not going to be $20 an hour. That might be their hourly rate, but it's not necessarily their regular rate because so many employees receive additional pay on top of their hourly rate. They get shift differentials, they get bonuses, they get commissions, any number of types of pay that they'll receive, premium pay for working off hours that are outside their normal shift, things like that. Presumptively, you should be including all of that in the regular rate, and it's a pretty easy calculation. But a lot of companies miss this in various pockets. There are really only a couple exceptions to the rule that all compensation should be included in the regular rate, and they fall into a couple areas. One is if a bonus is purely discretionary, meaning it is discretionary in the amount and discretionary in fact. So whether the employee is going to receive that bonus and if the employee is to receive a bonus, how much that's going to be, those both have to be up to the employer for the bonus to be discretionary within the meaning of the FLSA, and that's pretty rare. Those might be, hey, we've just decided to give employees certain amounts for the holidays at the end of the year because we had a good year. That type of thing is discretionary. Those that are based at all on an employee's performance rating are not going to be discretionary in the vast majority of cases. Another might be that if you already include overtime compensation in the bonus, even if it is non-discretionary, that can be eliminated. So for example, if a bonus is a percentage of total earnings includes overtime, then you can exclude that. So if you say, hey, we're going to give you, an extra 3% of your straight time earnings, then you're going to have to include it in the regular rate. But if it's, we're going to give you an extra 2% of your total earnings, then that wouldn't have to be included. And finally, another area for exception, one of the major ones, is that certain, like for example, if there's weekend work that you pay time and a half for, or nighttime work for which time and a half or double time or whatever it might be, or holiday work is paid. Those type of premiums, depending on how they're calculated, are likely to be excluded from the regular rate as well. But everything else is included. So why are they shooting fish in a barrel? For a couple of reasons. First of all, it's really easy to get them certified as a class action because everybody is treated the same in this regard. Second, there really is not a whole lot of work for the plaintiff's lawyers to do. They don't have to make much of an investment. The only discovery they need to do is whatever pops out of the employer's payroll system. So that's pretty darn easy. So these cases are being brought with much greater frequency. They aren't, on an individual basis, they're not huge because if you don't pay overtime by the proper regular rate, let's say, for example, your hypothetical $20 an hour employee, overtime would be $30 an hour if you don't include additional compensation, but let's say there is additional compensation to be paid when the employee works more, so the regular rate actually wasn't $20 an hour, it was in effect $21, meaning that they should have received $31.50 an hour instead of just $30. It's $1.50 an hour. It's not necessarily that big of a deal. But when you add that all up across a large number of employees, because after all, everybody's going to be subject to these same payroll rules that are in your system, it adds up. You multiply it by 3 years, you double it for the liquidated damages that are available under the FLSA, then you're going to see that these damages can add up pretty quickly, and of course there's the plaintiff's counsel's attorney's fees to pay as well. The good news in this area is that it is, as much as it is shooting fish in a barrel to bring the claim, it's also shooting a fish in a barrel to stop the claim, or I should say prevent the claim in the first place. All you need to do is look at all your pay codes, figure out which ones apply to your non-exempt employees, and of those, which ones are currently not included in the regular rate. And then you can take a look at each of those and decide whether it's appropriate or not, and of course consult with wage hour counsel on that too. So that unlike a lot of other claims that require a lot of rolling up your sleeves and require a lot of attorney expense, these are relatively inexpensive and quick to prevent. So we'll now move on to mistake number 5, and these next claims all relate to really the same thing, which is off the clock work or pay for all compensable hours. We see probably more claims like these than any other in terms of sheer numbers. They typically don't drive as large a settlement because they apply only to the employees who have been always classified as non-exempt. They're going to tend to be lower paid, and they're also going to be, in some ways, a little, probably going to be the most difficult to certify as a class action for the plaintiff's lawyer. That's why they don't typically get as large, but they do get brought a lot. And these involve all sorts of things that we're going to look at in the next few slides. They're typically more often now involving what some call wage theft and anti-wage theft laws that really are just if an employee is shorted some money for some time they worked, state laws are now throwing a lot of additional penalties on that under this wage theft statute. Those statutes are typically aimed at employers who just don't pay, who literally take the money that's supposed to go to employees who often are immigrant populations and have few protections. They're well-intentioned laws, but they're being used in a much broader way these days. And what I'd like to stress here, and what we'll see on the upcoming slides, is the key on all of these is to take a strong stand against off-the-clock work. There should be the right policies in place that are going to tell your managers what is time they should be instructing their employees to put in for. Employees themselves should be instructed in that way, and if they are, you're pretty well protected. I don't want to say you're absolutely protected, but you're pretty well protected against these claims, especially as compared to when you don't have those policies. And of course, training of employees on that is necessary as well. Let's go on to mistake number 6. which is a few examples of the specifics of when an employer doesn't pay for all time worked. The vast majority of which we see is the pre-shift and post-shift work. These kind of fall into, I'd say, 4 categories: pre-shift, post-shift, meal periods, and just, let's call it, off-shift. And let's cover pre- and post-shift first. A common type of claim that we'll see is, let's just talk pre-shift for a little bit, someone donning their uniform. A couple simple rules on this. If an employee is able to put on their uniform at home before they get to work and wear it there, you don't have to pay for that if they opt to do that at work. But generally, if you do make them put it on at work, there is often a risk that a court is going to determine that that work is integral or indispensable to the employee's principal work activities. And when that happens, it means that they've got to be paid for it. So, and they also have to be paid for anything else they do after putting on that uniform. So, for example, if an employee's shift starts at 8 a.m., but they arrive at 7:40, and they put on their uniform, it takes, say, 10 minutes to do that and to grab whatever equipment that they need to grab, and then they walk from there to their workstation. That takes another 5-10 minutes. And then they want to be there a little bit early because you don't want to be late because you got to keep that line going, or you got to make sure you're there for customer service purposes or whatever it is that your job entails. You're going to get paid. Technically, you should be on the clock from 7:40, not from 8 o'clock when your shift starts. And that's a common misconception. Now, if, however, the employee, there's ways you can stop this. You could allow the employee to put their uniform on at home. You could tell them that, hey, all your tools and everything you're going to need for your job is going to be at your workstation. Then you only have to pay them once they start work at that workstation. You don't have to pay them for that walking time. You don't have to pay them for the donning and doffing time, and that obviously makes things a lot easier. Some other common things are, for example, pre-shift meetings, or perhaps in a call center environment, or someone who does a virtual call center at their home and works from there. I know a lot of you probably employ telecommuters who might work in some sort of customer service capacity, where they're able to just set up a phone and a computer at home. They may have emails to read, directives to read before starting to receive or make calls. All that is time generally that will be regarded as integral and indispensable to their principal work activity, and thus is something that needs to be paid for. Some of these are going to be, there's going to be times when an employee isn't doing much of anything, and you might say, gee, there's no exertion involved. But guess what? That doesn't matter. That type of that under most court precedents doesn't matter. It still can constitute work even if it involves no real work, so to speak. It may also involve small increments. And there's a doctrine called the de minimis doctrine when it's only a couple minutes long. But there's a lot of exceptions to that. So if that de minimis work is something that is administratively easy to capture, which in the systems that everybody has these days, and that are really easy to capture. There's no reason not to, and courts now kind of expect employers to use those systems. So claiming that, oh, there's no way I could ever capture those couple minutes of work, courts are generally going to say, no. I know that there are several things on the market that you could probably purchase for a very reasonable price, and therefore pay your employees properly, but you've made the choice not to do that. You're not going to be able to save that money on your employees' backs. A lot of courts are going to say things like that. So the de minimis, and as that time adds up from employee to employee, and day after day, and week after week, and over 3 years, the de minimis doctrine gets to be one that you can't necessarily count on. And also, if the employee is, even if they're volunteering to do this, they're not being made to do it, it doesn't matter, because if you know or have reason to know that the work's being done, even if it's something you don't necessarily want being done, you got to pay for it. That's kind of become black letter law under the FLSA. So let's move on. And one other area I should discuss a little bit is, we have all these things that can happen before or after a shift, but we also have a lot of work during meal periods. Generally, an employer has to pay an employee from the time they start work until the time they end. The one time you can reliably take out is a bona fide meal period, which is going to be usually about 30 minutes. There's circumstances where it can be less, but the key is that the employee be completely relieved from duty during that time, and they can effectively use the time for their own purposes, and that it be predominantly for their benefit rather than the employer's. Then you don't have to pay for it. So let's move on to mistake number 7, which is our fourth area, pre-shift 1, post-shift 2, meal period 3, and others what I'll just call off-shift. What this typically involves is kind of your Blackberry claims. Employees have phones, cell phones, they have iPhones, they have Blackberries, they have Droids. They just have internet connections at home and are on their laptop or their iPad or whatever it may be. And often they're able to access their email and other work applications from wherever they are, and this is all very convenient. We want them to because we know that we have mobile employees, and we often want to reach them in case of emergency, and this is a really easy way to do it. The problem is that if they are working on those things, we have to pay them for it, and it may be that they are in small bursts of activity at random hours of the day, and it is hard to track. But if a manager knows that they're doing it, if a manager is emailing with an employee over something that takes more than a de minimis amount of time, they need to be paid for it, and steps need to be taken to track that time. There are some companies that will prohibit their non-exempt employees from even having some of this equipment, but frequently companies are finding that that is not a business practical way to go about things. Others will just say, this is for work time only, don't use these when you're not at work. But much like the Field of Dreams movie, if you give them the technology, they will use it. So you're probably going to have employees that if you do give them Blackberries or any smartphone like that, they are going to use it for various things, and it will probably include work. Our employees do tend to be pretty dedicated, but they have to be paid for it. This is where policies can come into play. If employees are given a reasonable means by which they can report the time, and they report it, you pay them for it, that's easy. If you give them the reasonable means to report it and they don't, then you've got a pretty strong argument that you don't have to pay them for it, at least not on a class basis. And that provides a pretty good defense to that claim. So mistake number 8 would be a final area of hours worked that we see, or not paying for all hours worked that we see, and that's travel time. And the rules here get to be, at first blush they're pretty simple, but they do get a little more complicated. Ordinary home-to-work travel that we all do is something you don't have to pay for. And if an employee chooses to live far away from their employer's site, that's their problem, not yours. So if they spend an hour driving to work because they tend to just live far out, too bad. If, however, the employer requires them to go out of town, then generally they do have to be paid for it. And if there are certain exceptions for off-hours travel, especially when the employee is performing no work while traveling, but these often don't apply under certain state laws, so you have to be careful with that. Where we typically see problems on a class basis is when employees kind of have roving work sites, or they have kind of a route to drive, and they go from their from their home to a customer's job site, whether that be a home for, say, a technician or repair person, or to various businesses that they service as part of their job. And they may go straight from home to the customer's work site, and maybe go to various customer work sites during the day, and then drive straight home from there. What happens then? Well, typically, if the commuting time where an employer goes from his home to the employer work site, even if that's a customer's work site, that's still non-compensable. But what we see happen frequently is that there may be various activities that they engage in at home first. They may be checking their email. They may be receiving directions on what to do. Once they get to the customer job site, there may be administrative paperwork for them to complete. That may start the clock on the workday. Not only do you have to pay the employee for that, but oftentimes, depending on the facts of the case, you may have to then pay for that commute between the home, which in effect becomes the first job site of the day, and then the first customer job site of the day. And on the back end, it's the same thing, and that can add up really fast. Now, before we move on to our next mistakes and to a polling question, there is one question I see, which is an overview on the difference between a discretionary and a non-discretionary bonus. And essentially, a discretionary bonus is something that the employee has no expectation of receiving. And if they do receive it, it will be in an amount that they have no basis to calculate it. If, for example, an employer says, if you achieve a certain production goal or achieve a ranking of X, we are going to pay you a bonus. Then the employee knows that if they reach that goal, they will get the bonus, and that's going to mean that the bonus is non-discretionary. The employee may not know what that bonus is, or I'm sorry, how much it's going to be, but they know they're going to get one. That makes it non-discretionary. Then it has to be included in the regular rate. Another way it might work is, you might have a bonus program where you say, from time to time, the company pays out discretionary bonuses. It's totally up to us whether you, employee, will get one. If we do give you one, it will be $500. Or it will be based on X% of your base rate. If there's a calculable way of figuring out what it is, and the employee knows that, hey, if I do get a bonus, it's going to be this dollar figure, then it's not discretionary either. It has to be discretionary both in terms of the fact of the payment and the amount of the payment. So it's a pretty difficult standard to meet. So let's move on to our polling question. Which is, do you think your company has not necessarily paid all non-exempts for all time worked? So if you think there's some areas where your company may have missed, then you should be answering yes. If you're very confident that no, we paid for everything, then hit no. And we'll give you 20 or so seconds to answer that question.
Okay, and we're going to go ahead and close the poll now.
Pretty good. I see a fair amount of confidence that we've paid everybody for all that time work. That's encouraging. We truly hope that's the case, especially for those claims that are easily susceptible to class or collective action. I'm now going to turn it over back to Rebecca to talk about a couple other mistakes that we tend to see.
All right. So mistake number 9 is a growing trend in litigation, where we see more and more litigation related to, did the employer pay trainees or interns for hours worked? And, I got an email the other day where somebody said, look, I'm looking to have an intern come work with me over the summer, no pay. They'll be doing discrete projects, and let me know if any of your kids want this kind of a job. That is exactly the kind of position that more plaintiffs' lawyers are going after, unless it's related to school, where you go to your school and you take a particular class that requires you to do an externship somewhere, and they're getting school credit for the work they're actually performing, or it's school training similar or analogous to that, and it really is for the benefit of the employee, not the employer, and no other regular employees are being displaced. And the employer truly doesn't get any advantage, and maybe their operations are even impeded in some way because the intern is there. They have to go out of their way to work with the intern and to train the intern and to teach the intern. And then there has to be an understanding that no wages are owed and there's no entitlement to a job at the end. If all of those criteria are satisfied, then the person can be considered an intern or an unpaid trainee under the law. But most interns, as we have traditionally used that word, probably need to be paid for their time. And more companies are being hit with lawsuits related to that. Going on to mistake number 10, This is the final mistake in our presentation today, and it truly is one where we would encourage you all to consider. Those employers who don't audit their pay practices and their exempt status are really putting their companies at risk. A good audit sits down and takes a good hard look at all of the pay practices, such as those that Noah was talking about, looks at all the exempt status classifications, goes through and says, are these people truly performing the types of duties that would qualify for an exemption? Have we complied with all the state laws? Lots of states have different laws than what the federal law permits. And so if you have a growing workforce, maybe you started out in one particular state, but now you've moved to 3 or 4 different states, that's a great opportunity to look into your pay practices and make sure you're complying with all of the relevant laws. Finally, we would recommend that you conduct these kinds of pay practice and exempt status audits at the direction of an attorney. And the reason for that is then if an attorney is the one who's conducting the audit or directing the audit, then there's an argument that can be made that that information is privileged and doesn't have to be produced in future litigation. Oftentimes in audits, we find that there are problems or places where an employer doesn't precisely comply with law or where there's a gray area. A position might fall into the administrative exemption, but maybe there are arguments that it doesn't. That's not the kind of information you would ever want to produce to the Department of Labor or to an opposing counsel. And so by having your own defense attorney help you conduct this audit and make sure you're doing everything correctly, then that protects that information. It also gives you a good faith defense down the road if you've done something pursuant to the direction of counsel and it was good wage and hour counsel who were experienced in wage and hour matters, and they gave you an opinion that you could do something, and it turns out they were wrong. Sometimes that happens. Judges decide to change the law, or the Department of Labor changes the law. Then having an audit that you conducted can help you avoid damages down the road in the future. And with that, we've come to the conclusion of Saifar Shah's part of this presentation, and I'm going to turn it back over to Michelle. Thank you all very much for taking the time to join us this afternoon.
Thanks, Rebecca. Noah, that was just great. I'm sure all of you on the phone would agree. That was just really some very powerful information and very helpful. I want to let you know that Rebecca and Noah and Saifar have put together a special white paper for us. It's called the Trend Watch, the Savvy Employer's Guide to Wage and Hour Lawsuits. If you'd like this white paper, just let us know at the end. Again, when you exit today's session, you will get a survey, and you can just answer yes and no to a few questions, and one of those will be asking you if you would like this bonus that Saifar has put out there for all of you that have attended. Again, it's a pretty cool white paper, the Savvy Employer's Guide to Wage and Hour Lawsuits. So thank you very much, Saifar and Shah, for giving that to our listeners today. Before we wrap up, I just want to cover a few things regarding EPAY. Since 2001, EPAY has delivered innovative and efficient and effective solutions to address our clients' critical time and labor management issues. And we serve clients across multiple industries: healthcare, security, food service, transportation, public sector, and so on. And one of the central themes that we hear from our clients is that we can mirror their operating environment. So we have built-in flexibility so that we can manage some of those difficult pay rules, shift differentials, things like that Noah and Rebecca talked about today, and we can handle these issues so that you don't end up getting into a compliance problem. Now, one thing, again, like I said earlier, is that we promise our clients that we can get them a 5% or more reduction in labor savings. And we do that through a number of things. We do it through our biometric time clocks, or our mobile technology where you can gather punches on these type of devices, ensuring that you have security and you have a minimization of buddy punching. We do it through our flexible payroll engine so that overtime is calculated right. You take in these blended rates and things that Noah was talking about so that they're done properly. Also, by automating right away, you eliminate a lot of time rounding that is done with pen and paper. So you can see a savings quite quickly. And of course, you can reduce the amount of time that it takes to put your whole payroll together. Now, again, we do spend a lot of time both working with Cypher Shaw and others to develop our cloud-based system so that we have compliance factors built right in. Let me talk just briefly about a couple of things that we do. First of all, audit trails. You know, changing an employee's time card without his or her approval is surprisingly a very common FLSA violation. In our system, which we call Blue Force, it flags all unapproved changes so managers can address them before they become issues. We also have many types of reports, ad hoc reports also, but reports where you can see where changes have made, and you can also set benchmarks and audits when you see a particular site having too many changes. Overtime, you know, calculating overtime properly is a huge litigation concern, as Noah brought up, and Blue Force tracks work time to the minute and automatically notes when an employee reaches overtime. We can automatically calculate overtime for the user, including blended overtime rates, taking into account different differential pay rates and different tasks that they're performing. Meal breaks is another one. You have to make sure that your folks are taking their meal breaks properly. And Blue Force asks employees if they've taken their proper meal breaks, and very soon we will have a soft meal break reminder so that if one day they forget, the next day they're reminded. But of course, you get all kinds of alerts and reports to make sure you can monitor this. Pay differentials, when a single employee is paid varying hourly rates, depending on a shift or task, it can create a real headache for your payroll staff. With the flexibility of our payroll engine, we can handle that from the onset. And then, of course, privacy and security. Our time tracking system keeps you in complete compliance with Sarbanes-Oxley so that you know that definitely that people have a separation of duties, that one person is submitting timesheets, the other one is approving. And we can provide that documented proof that your employees and managers only have access to what they should. And finally, workplace safety. We know that workers' compensation claims can be a real expense, and that's why we've built a rather unique safeguard into our punch-out procedure. At the end of each shift, employees are asked if they had a safe day, and the benefits are twofold for you. One, if an accident occurs, you're instantly in the loop, and two, if a questionable claim is made later, you can have some documentation of your own. So we've done this for a number of clients, and you can see some of those up on the slide today, from large to small. Again, EPAY provides a very flexible payroll engine, flexible data collection. You can gather your data in a number of different ways, from smartphones, tablets, to biometric clocks, to PCs, to the regular old telephone. And flexible communication. A lot of times, if you're at a remote site or a client site, you don't have access to their LAN, and so you need cellular to be able to move those punches from a clock up to the cloud, our cloud-based system. And so we can handle any type of communication. So let me tell you a little bit about some upcoming education if you'd like to know more about EPAY. We have a session actually tomorrow. We're going to be doing a public demonstration with John and I on just taking people through the Blue Force system. And then those of you that have mobile employees, we are going to be talking about new time and attendance technologies for the mobile workforce on March 7th. Just go to our website, and on the left-hand side, you'll see that little graphic, and you can see our schedule of classes. Now, we're going to have Cypher Shaw back for 5 more sessions this year. We're so excited to have this series. And you can see on this page, or you can go to our website, and you can catch all these classes. They're listed up there, and register for other ones. For those of you that have colleagues in other industries like construction, staffing, healthcare, and hospitality, they have their own sessions coming up. But for those of you that are not in those industries, you might want to take note of June 26th. We will have a special session on California wage and hour labor law. Again, you can register at epaysystems.com. So I want to thank Noah and Rebecca. Again, you guys did a great job, and it was so very helpful. Thank you to Cypher Shaw for having you with us today. And I want to finally wrap up again to make sure that you can connect with us. When you exit, you'll get the survey. Please go ahead and take it. You can indicate if you want any of those reports or if you want a copy of today's slides, or if you have a question for Noah, Rebecca, or myself on EPAY, please just say yes and we will contact you. Connect with us online. We have our Twitter and our LinkedIn up there. Also, on behalf of my friends at Cypherth, I want you to remind you that they have a wonderful blog, and you can go to wagehourlitigation.com and sign up for their blog. Of course, come to EPAY Systems and sign up for our newsletter or follow us on Twitter, and we'll be sending out little bits of information too, especially as regards to compliance and time tracking. So that's all the time we have today. Noah, Rebecca, John, and myself would like to extend a big thank you to all of you for joining us. We'd like to be your time and labor management provider. At EPAY, we're in time with you. Until next time, then, have a wonderful rest of your day.